Welcome to the Peel Community Legal Services presentation on minor civil claims. Please be aware that this video is intended for information purposes only. This is not to be relied upon as legal advice. You should always seek advice about your own personal circumstances. A minor civil claim is a claim that is valued at $10,000 or less. The person who lodges the claim is the claimant, and the person or group against whom the claim is made is the defendant. A minor civil claim is made in the Magistrates Court of Western Australia and is heard in the minor cases stream. The process of making a claim in the Magistrates Court will be discussed later in this presentation. On the screen now are various features of a minor civil claim. As previously noted, a minor case claim is for the value of $10,000 or less. Neither the claimant nor the defendant can be represented by a lawyer in court unless leave is granted by the court. There is minimal costs risks associated with a minor civil claim. The court will only order payment of filing fees, service fees, and enforcement fees. The minor civil claim process is relatively informal compared to other court processes, and the court is not bound by the rules of evidence, but it may be informed by them. Before you lodge your claim, you will need to figure out the value of the claim. You can do this by considering the amount of money owed by the defendant, the value of property damaged, the value of property that you are seeking to recover, or in the case of a claim to recover real property, the gross annual rental value of the property. If you feel that you have a minor case claim, before you apply to the court, you should send a letter of demand to the defendant. A letter of demand sets out what the claimant believes is owed to them by the defendant and is the first step in the minor civil claims process. The letter of demand should contain the following features: an explanation of why money is owed by the defendant with evidence the defendant knew of the debt. The letter should clearly set out the relevant dates, agreements, and amounts. The letter should set out a clear timetable for further legal action unless payment is made or a settlement proposal is received. And the letter should be sent by registered mail and the signed postal receipt kept. If the matter is still not resolved after you have sent the letter of demand, you can then make an application to the Magistrates Court. The first step in the court process is completing and lodging or filing your Form 4 minor case claim. This can be done through the eCourts portal using the assisted lodgement process or the e-lodgement process. Read each component carefully and seek assistance with any details that you do not understand. To complete the Form 4, you will need the following information: the claimant's details, the defendant's details, including their name and an address for service, a summary of the relevant facts, a list of any documentary evidence you may have in support of your claim, and details of the remedy that you are claiming. From the eCourts portal, you can find the application form either by selecting the Magistrates Court tab under the Assisted Lodgement menu or the e-Lodgement tab under the Lodgement menu. Once you have completed the online application form, to lodge the application, you will need to pay the filing fee. The fee is either $163.52 or, if you have a concession card, $51.10. You will need to enter your valid concession card details in the application form for the discount to apply. Once you have made your claim, the defendant will have 14 days in which to respond, or if they are not within Western Australia, 21 days. They may admit the claim in part, or defend the claim. They may also ignore the claim and fail to lodge any response. If the defendant admits the claim in full, the claimant can then contact them to make an arrangement to settle the claim. If no response is received from the defendant within the required time frame, the claimant can apply for default judgment. This means the decision would be made by the court without any input from the defendant. If the time frame for a response has passed and no response has been filed, you will need to complete a Form 13 application for default judgment. This form is filed with the court and served upon the other party. Once this is done, a Form 10 certificate of proof of service by the bailiff or a Form 11 affidavit of service must be filed. If the defendant does wish to defend a claim and files their response with the court, the matter will be set down for a pre-trial conference. The court will attempt to find a settlement at this hearing without going to trial. Both the claimant and the defendant must attend this hearing. If you cannot attend for any reason, you need to contact the court to make arrangements with them. You may be able to attend by audio link over the phone. If you do not attend the conference, the claim may be decided against you in your absence. That is, it may be dismissed or go to a default judgment. There is no set process that a pre-trial conference follows. However, it is common for the following matters to be addressed or considered. The court may determine agreed upon facts. It may assess if the case applies to the minor case claims procedure. The court may assess counterclaims made by the defendant and claims by third parties. The court may make extensions of time to allow for additional claims and counterclaims. It may order parties to attend additional conferences or mediations. Or the court may order parties to submit or exchange relevant documents to the case that may later be used as evidence if the case is not settled. If your matter does not settle at the pre-trial conference, you will need to prepare for trial. You will need to make sure your evidence is prepared and in order. Make sure you have all your paperwork organised with enough copies for you, the other parties, and the magistrate. If you have witnesses who will support what you have to say, you will need to ensure your witnesses attend at the trial. Make sure they arrive on time. If you need to summons witnesses, this must be done well in advance of the trial. On the trial day, ensure you arrive early to court. The magistrate is the person who will make the final decision. To ensure that you have the best result possible, it is important that you follow the instructions of the magistrate and treat them with respect. Speak clearly when giving information and refer to the magistrate as Your Honour. The trial will typically follow a set pattern. First, the claimant will give their opening address outlining their claims and evidence. Next, the claimant will present their evidence and then call any witnesses. The defendant will then be given the opportunity to cross-examine the claimant and their witnesses. Next, the defendant will give their opening address, outlining their position and evidence. The defendant will then present their evidence and call any of their witnesses. The claimant will also be given the opportunity to cross-examine the defendant and their witnesses. The defendant will then give their closing address, explaining why the claim is invalid. Finally, the claimant will give their closing address, explaining why the claim should be granted. While this is the usual set procedure that the court follows, the minor case process is informal and flexible, and your matter may not follow this process. After both parties have presented their case, the magistrate will give their decision. They may do this verbally immediately following conclusion of the parties' cases, or they may reserve their decision and require the parties to reattend at a later date. The decision made by the magistrate takes the form of a judgment and is required to be followed. On the screen now are contact details of organisations who may assist you with your matter. The Magistrates Court can assist with some queries. You can call them on 9425 2222. You may be eligible for assistance by a community legal centre. You can find your local community legal centre by visiting the website on the screen. Finally, legal aid may offer assistance. Call them on 1300 650 579 or visit their website.